Hey guys, we're gonna get started. You ready to record? Okay. Okay. All right, I'm gonna go behind my podium. Okay. Oh, I'm sorry. Because I just felt like all of you know her. This is Ellen Bacon Wiley. She's now with CAP. She used to be with LADL for all the new folks as everything, the writ attorney and supervisor. And now she's in CAP, and she's gonna talk to you about how not to screw up.
As much as I can. Okay. I'm excited to be here and to see you guys. I put together a PowerPoint due to technical issues. You have it as a handout, but I still am going to go through it with you because I put in some screenshots and some important things in the PowerPoint itself. So you have two handouts. The one that has that cover page on it has all the cases, rules, statutes that I used in the PowerPoint. So everything that was in the PowerPoint is also in here. So sorry for being a little bit duplicative. So there's a few things I want to go over today. One is notices of appeal. It sounds pretty basic, but I can tell you as a former supervisor, it was really one of the things that I frequently forgot to tell attorneys how to do and how to do correctly. Some of them would bring them to me the first time they did it, and we'd go through it, and then it was sort of off and running. And since I've been at CAP, I've noticed some problems. Okay? So we're going to talk about sort of how to do a notice of appeal, even though it sounds pretty obvious, it's not. And I'll tell you what we're looking for, what the juvenile court's looking for, what the Court of Appeals is looking for. We're going to talk briefly about appellate issues. And I do this for two reasons. One, so when the appellate attorney calls you and says, I can't find an issue, you understand sort of everything that's gone into their analysis, and also to hopefully help you figure out how to sort of tailor your record to make the strongest appeal you can for your client. We're going to talk a little bit about Phoenix H's, which are the no merit briefs that you may get. Maybe it'll tick you off because you fought really hard for this client, you saw the issue, and appellate counsel didn't see it. And then we're going to talk about everybody's favorite issue, ineffective assistance of counsel, and sort of how we go through that, because I know, especially for new attorneys, you're constantly feeling like you screwed up, someone's going to sue you, your appellate attorney is going to submit an IAC against you, and I'm here to hopefully alleviate some of your concerns that it doesn't happen as frequently as you worry it does. So turning to the second slide, we're just generally talking about what is an appealable order. In dependency, the first judgment under Section 395 is that dispositional order. You may not file a notice of appeal from detention. You may not file a notice of appeal from jurisdiction unless and until that disposition has happened. The court has to make the child a dependent to have the authority to make that judgment to give you the right to file a notice of appeal. Of course, there's two big exceptions that you need to be aware of. One is restraining orders. Restraining orders are appealable no matter when they happen. If at juris the court issues a permanent restraining order, that's appealable. You don't have to wait for dispo to appeal the issuance of the restraining order. The second is 360B. 360B, the court doesn't do a disposition. But once that court orders that 360B, that order is appealable. If you felt that the entire petition should be dismissed, you want to take the appeal, that is appealable even though the court did a 360B instead of going to disposition. Hopefully all of you know, if you're in a situation where both parents are bypassed under 361.5 and a 2-6 is set, you are not filing a notice of appeal, you are filing a notice of intent to file a writ. Don't file a notice of appeal to get kicked, okay? And of course, I hope you all know the timelines for notice of intent are very short, and I will refer you to the writ department to go through that. Don't shake your head at me, Steve. Okay, so we're looking at 395. There are times, and it just recently happened with one of the attorneys, filed a notice of appeal from jurisdiction. I sent her an email, and I'm sure all of you have gotten either emails from me or emails from Stephanie Miller. If you haven't, count yourself lucky, saying, hey, you appealed from juris. Are you appealing from dispo? I see it was to happen on this date. There are times when the appellate attorney can join them on appeal and ask the court to sort of disregard the premature notice of appeal and go by the one filed after dispo. So if you screw up, all is not lost. Just make sure you file a subsequent one from the dispo order. Okay, timelines, which is, sorry, slide number 3. California Rules of Court, it's 60 days, okay? 60 days from the entry of judgment, you have to file that notice of appeal. Part 2 of that gives you an extra 10 days if you're in front of a commissioner. For dependency purposes, all dependency commissioners are considered a referee not acting as a temporary judge. So you have 10 extra days. Don't go by that. Forget I said that. 60 days. 60 days. Don't screw yourself. 60 days. It's sort of like when you set your alarm fast because you think you'll get up earlier, and then you start calculating in your head how many more minutes you actually have to sleep. Don't do it. 60 days. Here's another issue that's been happening. If you file a rehearing the same day you file your notice of appeal, that's fine. But once that rehearing is granted, you need to abandon that notice of appeal. Okay? We had a recent situation where a notice of rehearing was filed simultaneously with the notice of appeal. Rehearing got granted. Trial attorney didn't pull it. Record got prepared. Record came to us. We had to tell the Court of Appeal, sorry, abandon this one, because that first order no longer matters once that rehearing is granted. So please pull it. If the record has not been filed yet in the Court of Appeal, and I'll tell you how to check to see if it was, you can always file a notice of abandonment of your appeal upstairs. If the record has been filed, it becomes much more complicated for us to do on the appellate side.
Ellen, is it 60 calendar days or court days?
Calendar days. Calendar days, yes.
In regards to the commissioners who you do a rehearing on, is it correct that if a commissioner JTs and you want a rehearing on that you can't, your only option is an appeal?
I've not heard that.
Okay, so you can do a rehearing from any commissioner's order.
That's my understanding, yes. Yes, and also.
No, I know that to be correct. I'm saying it for the other.
Oh,
ones,
yes.
Because we've had a couple commissioners who have a misunderstanding from like that, that's kind of like the final.
No.
So
No, you can't file a notice of appeal. The other thing that we just had a situation in one of the courtrooms where this happened, you can also file a notice of appeal from the granting of a rehearing. If you take a rehearing on, I don't know, let's say Castro, and the department takes a rehearing on Castro and it's granted for rehearing, you as the parent have the right to appeal whether or not that case should have been granted for rehearing. So that's something else to keep in mind. If you thought it was solid and you went to Diaz and you want the court to consider whether or not that a rehearing should have even been granted, you can file that notice of appeal. And that's referenced in that timeline slide under Rule 8.406A3. That's what that's referring to. If you want to take a notice of appeal from the granting of the rehearing. If you think you have had a great argument at detention and the court didn't see it your way, your remedies are rehearing. Your remedy, if you're before a commissioner, your remedy is an emergency writ, for which I will refer you to your writ department, or a no-time waiver. You don't have the right to appeal a detention hearing, even if you think you were wronged. And the reasoning behind it is because the disposition order supersedes the detention hearing in the eyes of the Court of Appeal because it's a higher burden and there's more evidence. So if you want to challenge detention, those are your only remedies. It doesn't come to the Court of Appeal. The other thing that we've seen pretty recently is the court, let's say the court JTs with a custody order to dad. You have mom, she's pissed. She wants to appeal. Do not file that notice of appeal before that stay is lifted, you guys. It drives me nuts. You have to wait for the stay to be lifted. The court will usually make the order, sole to dad. I'm staying it for a week so that I can get the custody order. The notice of appeal cannot be filed until that stay is lifted. There's a way that the appellate attorneys can finagle it and do a motion, but they will like you a lot better if they don't have to do that. Okay? Yes?
In that case, what date should we put on the notice of appeal?
You can put the judgment date. So the judgment date would be the date that the court entered the order, but what typically the clerk's office will pull the minute order of the date the entry was done and the release of the stay. But legally, that's a premature appeal. And so it causes a lot of problems and a lot of headache for the panel attorneys. Okay, the next slide, you can't really see, but I'll tell you what that notice of appeal says is termination of jurisdiction and all other appealable orders during the life of this case. Okay, guys, that's not a thing. Not a thing. Now, as Jasminder has pointed out to me, that could be a thing. If you had detention, juris, dispo, JT all within 60 days, that could be a thing. That was not the situation here. What this is called is a collateral attack, and even though it sounds really cool, the Court of Appeal hates it. If you have an appealable order, you have to file a notice of appeal. You can't appeal at a TPR and say, but you know what, I didn't like those dispo findings, they weren't fair, I shouldn't have had to do a 52-week program. It doesn't work that way. Now there's, of course, exceptions, right? One is ICWA. I hope you all know that ICWA, that not following the appropriate notice or issues with ICWA at this point can be raised anytime. So even if there was an ICWA notice defect at dispo, the appellate attorney can raise it at TPR. I don't know if it's going to be that way forever, but the Court of Appeal does allow it because parents shouldn't be allowed to waive the rights of a tribe to intervene in a proceeding. The other issue is, the other time they can do it is when the clerk did not give notice of appeal rights to a parent after dispo. You did not advise the parent, it's not on the record, and there may have been a legit appeal from their dispo. But don't get into those. If it's an appealable order, you don't like what they did, have the parent file a notice of appeal. Going back to the life of this case, you have 60 days from disposition or TPR or 2-1-E or whatever. But specific for disposition, it doesn't matter if your detention happened 80 days ago. You cannot file that notice of appeal until that dispo happens. Doesn't matter if there's more than 60 days between juris and dispo, okay? Dispo is the controlling event no matter how long ago detention or juris happened, okay? Okay, the next slide has to do with the form. Hopefully you all know JV 800 is the form. I'll refer you specifically to A3. The notice of appeal must be liberally construed. So if you go to the next slide, which is page 6 on mine, I have 2 cases. One, Enright Hannah S. Appellate review is limited to issues identified in a narrowly tailored notice of appeal, followed by Joshua S. Notice of appeal are to be liberally construed. What happened in between was that rule was amended. So now it's liberally construed, okay? But you guys, don't get lazy, okay? Don't get lazy and just put all findings and orders that are appealable. Don't get lazy. And the reason is because what this does is tips off your second floor clerk's office as to what reporters need to be notified, what reports need to be pulled, if there was a prior record in the case, how much they need to add. So don't get lazy. You still have to identify a date or a judgment or something on it. The records, I will say, that we are getting are grossly incomplete. We are getting appeals from 2-6 hearings with no reporter's hearing. We are getting appeals from juris dispo with no petition. So you may have noticed you're getting a lot more phone calls from the appellate attorneys. It's not their fault. I don't know what's going on upstairs. Hopefully you don't have mics down here, but it's bad. It's really bad. So the more information you can put on the notices of appeal, the better. They may ignore them. I don't know. If you go to the next page, I did a screenshot of the actual notice of appeal form. So I want to go through a few things on this. Many of you are concerned about putting your name or your client's name in per at the top of the form. It doesn't matter. Only in the 10 plus years I've been working in and out of the Court of Appeal, only one time on a writ petition did Justice Turner come back and say, well, your attorney filed a notice of writ, so why can't you find an issue? We had to do a declaration. It was ugly. Justice Turner, may he rest in peace, is no longer on the Court of Appeal. So it really doesn't matter, okay? If you're more comfortable doing in pro per, go for it. If you want to put your name, go for it. It doesn't matter. The law is that when you file a notice of appeal and you sign it, you are presumed to have your client's consent to file that without evidence to the contrary. But please, let your parent know if you are filing a notice of appeal on their behalf. And I'm talking specifically about incarcerated parents. I've had 2 situations recently where the appellate attorney has written the incarcerated parent. The parent has written them back and said, I don't know who you are. I never said I wanted a notice of appeal, and we had to abandon them. Don't do it. It's really bad practice. There's no reason, one, that your client shouldn't know the outcome of the hearing if he or she wasn't there, and there's no reason your client shouldn't know that you do not agree with the judgment and you think there's grounds for appeal. The other thing about that form, of course, child's name, case number, you can see it's a small box, and I know now you guys have to designate by letter. And I don't know if the clerk's office is requiring you to do a separate one for child. The ones that we've been receiving at CAP don't have that designation. I don't know if that really has changed. Jasmine did.
So far, they're accepting one form with just the case number changing. So I put all the kids on one form, then just put A, B, and C, and they have accepted it.
Okay, so we'll continue to go with that until told differently. And the box number 2, this appeal is filed by. Guys, think about how you would feel if you were interviewing a client for the first time and said, how can I reach you? And they responded, well, you have to go through my attorney who might be too busy to get back to you right away. So you have to wait to get my contact info from them. It really sucks, okay? And the appellate attorneys have an obligation to contact the clients. This is the address that's going to be used by the Court of Appeal. This is the address that's going to be used by the appellate attorney to send them everything. And if you just write your address instead of your client, you are 100% on the hook to send them every letter you get from the Court of Appeal, every document you get from counsel, everything, and notify the Court of Appeal if and when you get a mailing address form. Don't put yourself in that position, if at all possible. I get it. There's some people that are transient. I get it. So you have to come up with some way to get them mail. And to be honest, some of these, I know some of you guys, and I look at some of these, and I know that no one in this room, but some people are just too lazy to go pull that file and find the address and put care of attorney. And it really is a pain. So if at all possible, put your client's name and your client's address in that box. The number 3, I request that the court appoint an attorney on appeal. I never really made much of this, but it actually is pretty important. When this is received by the Court of Appeal, if the parent was represented by LADL, they do not have to fill out a separate financial affidavit for the Court of Appeal. Clients that were represented by Vince Davis, Rachel Raymond, any of those, they have to fill out and complete a financial affidavit first. That goes to review by the Court of Appeal second, and the Court of Appeal then decides whether or not they qualify for appointed counsel. For LADL attorneys, they just assume that process has been done here, so they get it. So even though we get it with the minute order, some of the court clerks up at the Court of Appeal are new and may not know what they're looking for, so just check that box was represented by an appointed attorney.
Ellen, can
Yes.
you just make sure that Lancaster is still there?
Which one?
Here.
Are you still there? Lancaster?
Yeah, we're still here.
Thank you.
Yeah, we're here.
Good.
Okay. The next slide is page 2 of the notice of appeal. You don't have time, you don't want to do it, don't do it. Page 2 is optional, okay? But if you're going to do it right and do it complete, okay? The dates are super important, because I picked up one today and I realized that mom filed her notice of appeal on 10/17/2017 and mom's appealing the judgment on 10/20/17. So apparently I have a psychic mom who knew her parental rights were going to be terminated, which they weren't. And so she appealed this. So the dates are super important. I can tell when the clients have filled them out themselves because every box is checked going down. The other appealable orders, it's really important if you are trying to appeal a 388 petition, regardless of whether or not it was done simultaneously with the 26, that you check that box and put 388. If it was done in a different hearing, we may not get that reporter's transcript. So be sure that you're checking that as well. If you're appealing juris dispo, it's helpful to put all the detention dates, if you can, as well, because the panel attorneys are looking for ICWA, and oftentimes those findings are made, they should be made, prior to dispo. So if you can write those dates down, helpful. The final thing I want to say about the notices of appeal, I've hopefully hammered in all of you that you have 60 days. Here's the reality part. It is taking at least 4, sometimes 6 months or longer for us to get records. And as a result, I'm less concerned with the 2/6s, okay? Because really what's going to happen? I'm more concerned with the juris dispos. I know you have 60 days, but I beg you to consider filing them as soon as you have them and not waiting until the 59th day. I know you guys are busy. I know you have a lot of things going on, but just file them because it's taking us so long to get these records that in the past few months, we've had to get rid of some really good appeals. Ms. Dutra had a great one where her judge sustained a D case on a dad who was sexting unrelated girls that he was meeting on social media, and he has 2 little boys. And the kid, that was a D, and it was removed. She had a great case, so great that we think the department read it, and instead of doing an opposition, recommended HOP's JT. Because it had taken us so long to get that record, we implored and begged and pleaded with Dad, please just let it ride. No, I'm done with the system. If it gets remanded, I don't want to go back. I'm done, I'm out, and wanted to abandon the appeal. Joe Mellis had one with Greenberg. Greenberg added a count at juris on a non-offending father whose appearance had been waived and denied Mr. Mellis the right to a continuance. By the time we got that record, no fault of either of these attorneys, by the way. By the time we got that record, Dad had the kid, JT, please, Dad, please, just let us go. No, I'm done. I don't want. I got my kid. I got my case closed. I'm out. Okay. So that's what I'm talking about. Okay. It's not counsel's fault. It's the second floor's fault. But consider it because we're in such a pinch right now in trying to get these records in, get them out, get them complete, and get them to the panel attorneys to start reviewing them, that waiting on those juris dispo or even those 212 and F22s is really killing some of the potentially really good appellate issues we have. That's my soapbox. Okay. So the next slide sort of tells you where CAP fits into that. Your notices of appeal are filed upstairs. They stay upstairs for then they go to the Court of Appeal. Then from the Court of Appeal, they're assigned a B number, and they come to California Appellate Project to assign counsel. Okay. This process should be pretty quick. It's not. When we get these notices of appeal from the Court of Appeal, they come to one of the staff attorneys. I'm reviewing them to look for premature notices, you know, moms who file the notice of appeal 3 days before the hearing, those types of things. The ones that I've reviewed this week are notices of appeal that were filed in July. So they're sitting up there for months, and I don't know why, and we don't have an answer. But that goes, again, to just don't sit on them, just file them. Many of you, the client calls you and says, hey, I haven't heard anything about my appeal, and you say, oh, call CAP. Yeah, no. Sorry, guys. We can't tell them anything because we don't get anything until it's made its way here to the Court of Appeal, back to us. So the best thing to do is to probably look at the Court of Appeal website. So the next slide that I included is the Court of Appeal website. It's courts.ca.gov, the same one we probably use for forms. If you click on Courts of Appeal, you can search your case information. And then the following slide shows you can select second appellate district. which hopefully you all know we're in. And then you'll get the following screen, which says, enter the Court of Appeal or court case number. That's your DK, that's your CK, that's your, 17CCJPQFZ, exclamation point.
A, B, and
Hashtag.
C.
A. If you click on that, if you click on search by, you come over, you'll get a case summary. This happens to be Devin Taylor's case that I'm working on with her right now. So if you don't see anything there, it means that the notice of appeal is still sitting upstairs, okay? Because the Court of Appeal won't do anything until they know about the notice of appeal from the trial court, and then it will sit there. I didn't go to docket, but if you see there's a whole menu up there. If you click on docket, you will see, if CAP knows about it, it will say notice sent to CAP LA for counsel recommendation. That means we know about it, okay? If you see nothing at all, then you can call. I'm not trying to say you can't call us, but you may just call us and I'm going to tell you, I don't know, check with the juvenile court. If you go to parties and attorneys on that same menu, it will tell you who has been appointed for anybody. So if you represent mom, you filed a notice of appeal, mom called you and says, I don't know who my appellate attorney is, you could help her out by clicking parties and attorneys and saying, hey, your appellate attorney is so-and-so. If the case is completely done and the opinion's been filed, it will be here in PDF and doc. So if you have something that's remanded, reversed, sent back for ICWA, whatever, you should be able to easily find a copy of the PDF or the doc on this page. One other thing about CAP, we do not appoint counsel until that record's received. So it's not a matter of getting that notice of appeal from the court from the Court of Appeal and saying, okay, panel attorney A, you're on this case. We get the record first, and then we appoint counsel. Why we do that is because we have different levels of panel attorneys. We have some that are assisted, meaning that they may have limited dependency experience or they have limited appeal experience. Then we have independent, and those, we have some new independent and we have some OGs who have been doing it for years. The reason we don't appoint until we get that record is because if you're appealing a D or an E or something like that, that's not going to a new attorney. That's going to one of our OGs. Hopefully you, reading the briefs, won't know the difference as to whether or not it's an assisted or an independent case, but we do. So the next slide is Rule 8.409, which says within 20 days, the clerk must prepare and certify. You can just ignore that because the second floor does. But this is the rule. The Court of Appeal recently has really come down on the second floor for TPRs because they're designated as fast track cases, because certainly we want to get those babies to permanency right away. And so those are designated as fast track. And so the Court of Appeal has come down on them somewhat, but I just got one that was due in August, and I just got it incomplete. Okay, any questions about the notice of appeal, the process, how to find out the status of your appeal or anything like that? Yes?
About how long is it taking at this point from the filing of the notice of appeal to CAP being able to reach out and contact our client?
We wait for the record. So it's all dependent on the records. The records are taking, I got one pretty quickly. I have other ones that were due in August that we don't have yet. So I can't tell you because it's crazy. It's crazy. And then they're incomplete. So then counsel has to do a correction letter upstairs, say, I need this, I need the petition. I need this, and this. And by the way, Court of Appeal, I need you to stay briefing. So I can't tell you because it's just all over the place. It's all over the place.
But we can advise our clients, your appellate attorney will reach out to you when they
Yes.
sign the case. Or
When they get the record. When they get the record. It's hard to have a meaningful conversation with a client about their case until you review the record. And it was the same for me in Ritz. I couldn't talk to the client about their case until I had seen what it was about. And all they get are the last minute order, which says nothing. Yes.
Is there any statutory language or any cases that you're aware of that deal with this delay, like the equivalent of court congestion, and court congestion is not a basis to keep putting these over for so long?
There is
You
not,
take an appeal on this?
The Court of Appeal
Yeah.
for second floor violating
Yeah.
rule.
Yeah.
there's, how do I say this? We have to tread lightly at CAP, okay? Because we're sort of the go-between, the Court of Appeal, and we're trying not to tick off either party. And the Court of Appeal recognizes that. They recognize that the Superior Court is a separate entity. The rule is what the rule is. It says 20 days. And it also says that the Superior Court does not have the authority to grant an extension. That authority has to come from the Court of Appeal. So it's really going to be up to the Court of Appeal to go back. We don't have standing because we're just the go-between. So it would have to be the Court of Appeal leaning on the Superior Court and doing something about it. And that's a tussle I'm not willing to get into.
Can we, let's say we file it and then we follow it and nothing's going on, can we file another appeal on that process?
What's the order? There's no order to appeal.
You're right.
We're going to have to talk about that.
Okay.
Ellen,
Yes,
I have a question about
Yes.
the form.
yes.
As you're, I'm sure, painfully aware, 2 6s in Lancaster can be continued 15 times.
Yes.
How important is it to include each of those continuance dates on the form if all there was a submission?
If all there was a submission, if that's all that happened, and I know in Lancaster, they regularly continue them with a submission form. They do it by submission. Then that's fine. If there were any interim orders made, changes to visitation, liberalization, case plan, any other discussion, then we need that record.
And what about ROR dates?
No.
Thank you.
What if at the continuance, there's an attorney objecting to the continuance?
Then we probably want that. But although so the question, for those of you who didn't hear it, the question was, what if on the continuance date there is an attorney objecting to the continuance? We want that because it preserves that potential appeal issue.
Okay.
But I'm going to come back and say Jeff M. You guys, Jeff M. Especially in Lancaster. I cringe sometimes when I see how far these juris dispo hearings are going out without the standards under 352. And I'm, to be honest, worried that I'm going to get that phone call saying, Ellen, I think I have ineffective assistance of counsel because this case went out for 1.5 years, eating into mom's FR. I haven't gotten it yet. But I'm just Jeff M. Yes.
But it's okay to put every single 2 6. There's no harm in listing.
There's
all the
no
dates.
harm in listing them all. Not at all. Not at
That's
all.
not slowing down your record?
No.
Trying to find those reporters?
I don't know. I don't know if it is. They're slow anyways, too, with or without those. Okay, so now I'm going to turn a little bit to what the panel attorneys are looking at. And the slide, it's my number 15, is justiciability. It's a cool word. It makes you sound really smart. And for the first few times I saw it, I kept checking myself to make sure I was pronouncing it correctly and or spelling it correctly. But that is what it is. And basically, when you're sitting there thinking, well, crap, why didn't my appellate attorney do anything on this case? Here are some of the things to consider and that we at CAP consider as well. There has to be effective relief, okay, available to your mom or to your dad or to your guardian in order for them to raise an issue on appeal. If you go to the next slide, I have an example of this. So, and by the way, no ladles were harmed in the creation of this presentation. These are actually notices of appeal filed by ladle attorneys, but these attorneys I double checked are no longer with ladle, so don't sit there with this knot in your stomach saying, oh crap, I think that was me. I promise you it wasn't, okay? If you can't read it, basically the mother's attorney challenged the B2 count relating to mother's mental health and nexus. Great. But then I got the record, and counsel submitted on the other 2 counts, which were mom's substance abuse and inappropriate physical discipline of the kids. Now we have a justiciability problem. Because 1 count is enough, people. You need 1 count, and that's it. Now there are, so the next slide, IJ, basically says the same thing. When you have multiple grounds, all we have to do is uphold 1, and we don't have to worry about the others, okay? So if you do have a case like this, you got to think about how you can present it and whether or not you really want to file a notice of appeal. I get it. I know there are clients in your face saying, I want my appeal before they're dragged out by the bailiff, but, and you may have to file it, I get it, but I want you to sort of understand what goes into the thought process of the appellate attorneys when they're deciding whether or not they have something they can present to the court. So basically, IJ says the same thing, 1 count, we're out. So says the Court of Appeal. The next slide is from NRA DM. This is the issue where we have multiple counts against different parents and only one parent appeals. If we have a bogus count against the parent that appeals, but a solid count against the other parent, you're getting nothing. Because again, one count and we're out. So you may not be able to get something. There are exceptions, and there is a special way to do a little justiciability song and dance with jazz hands about why they should let us through the door to the club of the Court of Appeal. And basically what we have to show is that, yeah, but mom was really affected by dad's counts being sustained, something. I'm telling you, jazz hands, glitter, lights, everything to try and get these through. The next slide has the exceptions. So the big ones that we can automatically tack onto is when it's a difference between an offending and a non-offending parent. 2 counts against dad, mom's got 1 count, we're good to go with mom's 1, because we get that stricken, she's now a non-offending parent, and we have something to hook the Court of Appeal onto. Why wouldn't you want to make this mom non-offending, Your Honor? The second one is it could affect future dependency or family law proceedings. We're looking at, whether or not the kid was removed from mom and could have stayed with mom if this count had been stricken. Serves as a basis for dispositional orders also appealed. So we're looking at, the drug count that ordered mom into substance abuse when she probably only needed parenting because there was no evidence supporting that substance abuse count. And then policy. Court of Appeal is almost always going to look at those D counts, okay? Because nobody likes to be labeled a sex abuser, regardless of whether or not there were other counts that probably were appropriately sustained given the evidence. But in Brianna V, it was a registered sex offender. So we want to look at that. So those are the exceptions. The next slide I put in is entitled Appellate Review. Basically, the Court of Appeal is never going to touch credibility. If you have a D case, the victim gets on the stand, testifies, and the trial court says, yeah, I believe the kid, you're probably done, okay? Because the Court of Appeal has taken the position that the trial court's in the better position to see the witness, to hear the witness, to observe the body language of the witness, the demeanor, the crying, the breaking down, the whatever they're doing, okay? Then the Court of Appeal and the Court of Appeal will not second guess that finding, okay? Even if the kid testifying was the only evidence. Same goes if your clients take the stand and the court says, Dad, you're full of crap. I don't believe you, which recently happened to me. And then you're probably done too. There is one limited exception that I've only seen in one case where the Court of Appeal said, we're going to reconsider the credibility finding because it was absolutely absurd for the trial court to rely on that. Okay, and it was an expert witness too. So it's a very, very limited window, and it's hard to explain this to parents. I had to do so recently on a DV case where him and mom took the stand and denied that the DV and the breaking of items and mom's initial disclosure to the police and then recantation didn't matter because the court didn't find them credible, okay? The next slide I put in, because this was my pet peeve when I was here, arguments/representations made by counsel, and I'm talking about those CLC attorneys, okay? Not necessarily you guys, but the CLC attorneys. That's not evidence. It's not evidence. They can care so much about these children, and they can get it, okay? And they can have a lot of concerns, okay? It's not evidence, and it drives me nuts, okay? There's your cases, arguments of counsel, amount to unsworn testimony do not constitute evidence. And I would actually encourage you guys to go look at NRA AS, because that one's kind of bad. The minors counsel popped up and said, well, the minors therapist says, and nobody said anything. And then on appeal, they tried to bring it up, and the court of appeal's like, hey, no, you waived that. So just listen to them kind of, okay? Listen to their concerns and their long concerns, okay? But be right on your objections. You can all object to closing argument, especially if they are giving testimony or evidence that is not otherwise in the record.
Is the objection, that's not an evidence?
Sure. Yeah, or counsel's testimony. Okay, the next slide has to do with post-judgment evidence. And generally, there was a big Supreme Court case, Enriquez S. Down in Orange County, the Court of Appeal was regularly taking post-judgment evidence. You would have a 2-1E or a dispo, and then the Court of Appeal would say, well, let's tell us what's going on now. And then they would do whatever they were going to do with the appeal, regardless of what the record on appeal said. The Supreme Court got wind of this and said, yeah, no, you can't do that. So now the record on appeal is supposed to be limited to the four corners of the record at the time the hearing was taken. The exception to that is that the Court of Appeal can receive new evidence, such as minute orders, whatever, by usually the department or the respondent saying it's moot. Okay. County counsel downstairs submits minute orders on everything, regardless of whether or not it's moot. Shelley has a case. They just submitted a bunch of minute orders, and we went through it, and we're like, so what? Like, ooh, the case is still open. Ooh, you know? So this is where, to be honest, county counsel has the leg up on us. They are in the building. They can easily access minute orders. They can easily see what is the current status of that case, and they are filing motions to dismiss on every case they can. And so I know we kind of go through it, and I know I beg you guys, but please do not ignore your appellate attorneys, okay? They are trying to save your behind. They are trying to save their behinds because the court is kind of ticked when they don't advise the court that there's been something that's happened, either JT or whatever, that has rendered the appeal moot. That leads me to the next slide, which talks about the mootness doctrine. Basically, it's when a subsequent event renders it impossible for the Court of Appeal to grant effective relief. But again, there's exceptions. Material questions for the court's determination, a pending case poses an issue of broad public interest, or there's a likelihood of recurrence of a controversy between the same parties or others. The most common scenario we have is that the case JTs while the appeal is pending, assuming you've appealed from either a review hearing or a juris dispo hearing. A lot of the appellate attorneys are kind of hitting back with this in cases where your client could have had a khaki hit as a result of the petition, trying to defeat that mootness argument raised by the county. Custody determinations are a big one that we can usually defeat, and legal ramifications such as a sex abuse case or something ugly. The appellate attorneys really need to be prepared to counter a request for dismissal based upon any of these factors. In some cases, like Bridget's, like Joe's, we've had to abandon because we knew it was coming. We didn't want to look like assholes for trying to oppose it when it was clear. So we took the initiative and abandoned it because our client told us that's what they wanted to do. So turning to the next slide, and I'll kind of tie these two together, the effective appeal on jurisdiction. Back in the old days, Judge Nash, who was the former presiding judge, had a policy about not JTing a case while an appeal was pending from juris dispo or from a review hearing. It was policy only. There's case law, and I put it here for you in case you're in front of an old school bench officer, that there's just nothing that says you can't terminate a case while an appeal is pending. But that doesn't alleviate your responsibility to let the appellate attorney who may be working on your client's appeal know that that's happening. We do not, at CAP, we do not have the blanket order that you must file a notice of appeal from all subsequent orders if you have an appeal pending from juris dispo or review hearing. But we are asking you to at least contact the appellate attorney to let them know what's going on so that they can tell you, yeah, you know what, I need you to file a notice of appeal from that JT, or we're just going to let it ride. We're going to see what happens. They make that call. We don't. Okay? And Lena is very good because she had a recent published case where there were so many after events that she kept in contact with the appellate attorney that not only did her appeal survive, but it was reversed. It went all the way back to dispo because it was reversed. So please contact the appellate attorney if the case is JTing. I know they can be a pain. I know you guys don't have a lot of time. If the appellate attorney is calling you and you just want to shoot them a quick email and you don't have your email address, I have Cap's phone number, my email. You can email me. I'll give them your email address. Because there's one division right now who now just orders all minute orders for every hearing after that notice of appeal is filed, because this has become such a problem, because the Court of Appeal doesn't want to waste their time. They have a ton of cases, and they just want to get rid of the ones that they don't have to consider. The next slide is a no issue brief. As I hope you can see from the previous discussion about justiciability, it's not just about what the evidence was and whether or not there was substantial evidence supporting the trial court's decision. There's a lot of other things that go into this analysis. We can argue one count but not another, and so then we're kind of done. Or we know events post-appeal have just totally tanked the case. We get a lot of parents who appeal from what? I'm not sure. Progress reports, RPPs. So sometimes we just get weird appeals and we just have to Phoenix H them. If you look at Phoenix H, the last sentence, it says the Court of Appeal is not required to permit the parent to file an additional brief absent a showing of good cause. For now, the Second Appellate District automatically gives every parent 30 days. So they may call you and say, hey, I have to do a brief to the Court of Appeal. Can you help me? I hope your answer is no, okay, because it's kind of outside your contract. They usually, the appellate attorney is sending them the record. They're sending them the reasons why. They're sending them a copy of the Phoenix H brief where they're required to put the law in for them. And to be honest, I think, 2 out of 10 parents will actually go ahead and file something in pro per. As part of the Phoenix H, appellate counsel is required to do a declaration. And part of that declaration is that they have discussed the issues with mom/dad/guardians trial counsel. And I get a lot of emails saying, hey, I can't reach trial counsel. I know there's a lot of change in courtrooms too, but that's required. So they're not calling to tell you did a crappy job. They're not calling to bug you. They're not calling you to tell you what to do next. They're calling you because they're required to, because they have to put that in their declaration. And all they're saying is, hey, I got, Mr. Garcia's appeal. I'm not seeing anything. Was there anything that stuck out to you in the way that this case was handled? That's it. So nothing to be nervous about, nothing to be scared about. They have to, it's part of their declaration that they have to say they at least reached out and discussed the case with you. For those of you who are new, just sort of the process, when we assign an appeal at CAP, if the attorney, whether or not they're an OG or whether or not they're a new attorney, if they decide there's no issues, it has to be reviewed by an attorney at CAP. We have to sign off on any no merit brief before they file it. So at least 2 sets of eyes have looked at the entire record and their proposed brief and their issues and said, nothing here, okay? Then the next part I'm just going to spend a little bit about time on is effective legal representation, which is what we're going to try and call it now. If you ever have a really crappy day, go ahead and read Ernesto R. Because this is one of the cases where I'm like, yeah, I think counsel probably should have filed a 388, but the Court of Appeal said it was a clear loser. But I kind of thought counsel should have. So there's no obligation for you to file a 388 that you don't think is meritorious. And if you drive home and think, man, I really screwed up today, read Ernesto R, because it'll make you feel a lot better, okay? Because the bar is pretty low, people. The bar is pretty low. Anna C has some great language that I hope will just kind of boost you up. There's no single required manner in which to litigate in a trial courtroom, and reasonable trial tactics may fall within a wide range of conduct, okay? So you guys know our process. If one of our panel attorneys says, hey, I think I have an ineffective assistance of counsel claim here, we have to be consulted first. If there's absolutely no other way to raise the issue that we're trying to get to but the IAC claim, then we give them permission to be pursued, but we're part of that process. It's not like we say, yep, go ahead. We're part of that process. You should never, ever, ever receive a brief saying that the parent received IAC without any knowledge that it may be coming, without any consult, anything. And if you do, we need to be notified right away. It has happened. We've got panel attorneys who go rogue, okay? And do not discuss it with CAP. And when we've found out, they've had to pull the brief. That means file notice with the Court of Appeals saying, yeah, never mind that brief, I'm going to file another one. attorney and take that section out. So it's taken very seriously. It's gotten people's jobs on the panel placed in jeopardy when they do that, because we know how serious it is. Of course, I've been in the trial court, Stephanie's been in the trial court, everyone in our unit has spent time and years in the trial court, and we get it. And we don't take it lightly at all, okay? So there's no reason why this should ever come as a surprise to you that the panel attorney was looking at something. They're supposed to always call a supervisor or a firm head to discuss it before any of that happens. So don't assume every call or email from the panel attorney is IAC or fishing for IAC. And honestly, if the way they phrase it is uncomfortable, talk to your supervisor, talk to your firm head, and just say, hey, I got this email, I'm not sure, can you look it over and help me respond? It's not a big deal. CLC gets IAC too. I have one on my desk right now, but we may have a legit claim of IAC against CLC for failing to declare a very obvious conflict. Okay, so it's not just parents we're looking at CLC too. The last part I'll say about this is document your file. Okay, we had a case this summer. She's not here, but I'll say it anyway because she was fine. Carolina Villamil's client got literally dragged out of the courtroom by the bailiff with some choice words for Judge Downing, and in the middle said, she never filed a 388 for me, amongst the other horrible things she said to Judge Downing. Dragged out. So appellate counsel, doing her job after mom files that notice of appeal, says, hey, Ms. Villamil, what about that 388? Ms. Villamil was out of the country, but Ms. Firth was able to pull that file, look and say, nope, she contacted her here, 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 and here. And mom said she would get her the documentation and never did. So document your file. You guys have too many cases. You're not going to remember every detail, every conversation, every contact you've had with a client, especially between the time their FR is terminated and that 2-6, and they can and they will come back and complain to that panel attorney. I asked Ms. Nicola to file a 388 for me, and she never did. She never returned my calls. And you got to have it documented, okay? Because the panel attorney is not trying to nail you, but they have the responsibility to at least follow up on those claims. So document, 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 document. Because that's the only record you're going to have, or your firm director is going to have if you happen to be out of the country or moved courtrooms or anything like that. It's your protection. And the last slide is just our contact information. You guys, if you have any questions, any problems, you don't know how to fill out your notice of appeal, anything, then just email me or call me. We have 3 attorneys in the dependency unit. We divvy up the cases by the last digit of appeals, but if it's not my case and you have a case-specific question, I'll tell you who to reach out to. Any questions? Oh, my yes.
388.
Yes.
When? Where? I mean, like, when, with the 388, I've always confused, like, when does the 388 get brought into the 2-6 appeal, and then when it's pre-2-6? Just educate me on an appeal on a 388.
Steve, no. So it depends, okay? If you filed it, okay, because typically, ideally, you're dealing with only 120 days between the termination of FR and the first 2-6. Now, reality knows it's much longer than that because they can never get the adoptive home study approved and all that stuff. So it's much longer than that. If you file it before that, if it's filed and denied, and you still have more than 60 days until the 2-6, you have 2 options. You can do a notice of appeal, or you can do a writ, an emergency writ. In the past, the Court of Appeal has said it prefers writ because it's faster, but I'm not even sure the writs are that fast anymore because there's such a backlog. So you can file your own notice of appeal. Now, let's say 3 months later down the line, mom ends up TPR'd, she files a notice of appeal. What the Court of Appeal is going to do is consolidate those 2. And from CAP's purposes, they'll go to the same attorney. And it happens very frequently. Megan Calloway just did me a solid on this because her client filed a 388 from something way before the 2-6, filed the notice of appeal, sent it from prison, and then the 2-6 happened. So I followed up with her to make sure that the notice of appeal was filed so that we could consolidate
And prior to the 2/6.
Prior to the, when?
Like during FR.
If you filed a 388, like for a parent who didn't get FR,
Or like
Give me a
liberalized
scenario.
visits or HOP,
And was-
3 months into
okay, so
FR.
it depends. If it was decided in conjunction with the review hearing, and you can appeal that whole thing. So let's say you file a 388 right before the 2NF, and the court says, yeah, I'm going to set it for the date of the 2NF. You have the 2NF, the 388's denied, and services continue because no 2/6 is set, because if the 2/6 was set, you'd be going to the writ department, and no 2/6 was set, you can appeal that entire thing. If you just file one sort of in the middle and it's denied without a hearing or anything like that, you can, it's 60 days, you can appeal it. You can appeal it. We're very good, if I do say so myself, at flagging these subsequent appeals. So that we can make sure that the same trial attorney gets it. And it very frequently happens that we have attorneys who have taken the juris dispo appeal and now we're at TPR and we make a phone call and say, hey, repeat customer, can you take her back? And they are always willing to take them back. Yes.
An issue that I think has come up quite a bit is the 2/6 filing. It has, or the 380 has to be filed prior to the TPR 2/6 hearing. But the prior to is a little ambiguous. What if it's filed the day of? What if you're asking for continuance? I know there's case law, but it seems a little ambiguous to me still.
Well, it is ambiguous because there's no statutory guideline, and it's the case law. The case law says that if the court is aware that there's a 2/6 pending, or excuse me, a 388 pending, then the court must resolve that 388 before it gets to 2/6. Because there were some bench officers, and I think there might still be some, because I just saw one that will say, oh yeah, I just terminated parental rights for your 388 tonight. And that's just wrong. They can't, there's case law, and I want to say Fernando L, but I don't know that I'm right on that. But there is case law that says if the court is aware of a pending 388, that has to be resolved before the 2/6. If they don't and try to do it backwards, just make sure you put both on that notice of appeal so that we can bring it up.
So if you file it an hour before the hearing, for example, that's prior to.
You got to do what you got to do, right? If the client comes in and says, here's all my documents that I've had for the last 6 months, you got to do what you got to do. If it, and again, you can go back to Ernesto R. I mean, if, these were programs that were completed prior to termination of FR and your client's back saying here, there's probably not enough. So, you can use Ernesto R and you can decide, but I agree, yes. I've been there. There's clients who come in and you're handwriting that 388 at the last minute.
Right.
You got to do what you can. Yeah. But fortunately, your file's been well documented to say how many efforts before then you made to try and get this right.
Of course.
Anything else? All right, well, thank you, guys. This was fun.